The 14th Amendment is central to our modern legal landscape. Decisions in cases like Brown v. Board of Education, Bush v. Gore, and the now overturned Roe v. Wade all have a legal basis in the 14th Amendment. So how can a single constitutional amendment apply to so much consequential legal precedent? Well, like a lot of things, it's a matter of who's doing the interpreting. Ratified in 1868, the 14th Amendment was one of 3 Reconstruction-era constitutional additions aimed at abolishing slavery and establishing legal and civil rights to formally enslave Black Americans. Divided into 5 sections, Section 1's language has been central to issues beyond slavery, including desegregation, voting rights, abortion rights, LGBTQ protections, and beyond. First, there's the Citizenship Clause, which establishes all who are born or naturalized in the U.S. as citizens. In practice, this nullified the notorious 1857 Dred Scott v. Stanford decision, which had excluded the enslaved, formerly enslaved, and their descendants from enjoying basic constitutional rights and protections. So how does that all play into today's politics? Look no further than former President Donald Trump, who as recently as 2019 argued for an end to birthright citizenship, as protected by the 14th Amendment.
Hundreds of thousands of illegal immigrant children are made automatic citizens every year because of this crazy policy.
Next, the Privileges and Immunities Clause, which provides that states can't make or enforce laws that, quote, abridge the privileges or immunities of citizens. That scope was considerably narrowed in 1873, thanks to the landmark Slaughterhouse Cases decision, which held that the clause extended only to the explicitly written enumerated rights included in the Bill of Rights of the Constitution. Those rights, the majority argued, applied on the federal and not state level. In practice, that meant states were able to pass and enforce discriminatory laws typical in the Jim Crow-era South. That narrow ruling leads us to the Due Process and Equal Protection Clauses, the interpretations of which have been used to extend a series of unenumerated or inferred rights not explicitly coded in the Constitution, on both the state and federal level. That debate on whether a right needs to be explicitly written and not inferred in the Constitution sets us up for many of the contentious legal debates of today. First, due process, which echoes a sentiment so important to the framers they included it twice in the Constitution, establishing that the state, quote, can't deprive a person of life, liberty, or property without the due process of law. Next, the Equal Protection Clause, which establishes a state can't deny an individual equal rights, mandating equal treatment under the law. The number of cases decided on these grounds is vast. In Brown v. Board of Education, the court unanimously found racially segregated schools to be inherently unequal, thus violating the equal protection of Black Americans. In Bush v. Gore, the court found that a lack of standard vote counting methods across Florida violated the equal protection of voters, effectively ending the recount. In Obergefell v. Hodges, it argued that prohibiting marriage among same-sex couples violated their due process and equal protection by denying them a right available to heterosexual couples. And in Roe v. Wade, the court found that a right to privacy under the Due Process Clause protected a woman's right to choose whether to have an abortion. The court's follow-up case, Planned Parenthood v. Casey, touched upon equal protection. It's those interpretations that were ultimately struck down in a majority opinion authored by Supreme Court Justice Samuel Alito in the Dobbs v. Jackson Women's Health Organization case. At its center, the opinion suggests that a, quote, loose interpretation of the 14th Amendment was incorrect, because abortion is neither implicitly mentioned in the Constitution or entrenched in our history or legal traditions. Now that Roe has been overturned, many worry future reversals of, quote, settled precedent like same-sex marriage and voting rights could be challenged next.